I'm not about to tell you anything that is not already in some outline somewhere. We haven't said it before. But sometimes it's useful not only to see stuff in print, but also to have heard the irritating voice repeatedly saying something. You tend to remember that. I've had students say they can hear me talking while they're taking the bar exam. So on the theory that hearing it has some value in addition to being able to see in paper, you're going to hear some stuff. So with intentional torts, the safest way to do it is to start with, we're talking about wrongful conduct. So you start with conduct. And the first requirement for any intentional tort that you're going to have to prove at trial is that you've got volitional conduct. It ordinarily will not be an issue on an exam. You don't have to bring up that it's volitional where it's obviously volitional. But where it's not volitional, then you've got to note that and say the intentional tort fails because the conduct causing the wrong, whatever it was not volitional. You have an example of that in one of your practice exams where I've got someone vomiting on a rug. The vomiting is not a voluntary conduct unless it's a bulimic or someone trying to induce vomiting, then it would be. But ordinarily vomiting is a reflexive, non-volitional conduct. You can't stop it from coming up, it comes up. In that fact pattern, for instance, the person did vomit, which is non-volitional conduct, but then she chose where to direct the vomit, which turned it into volitional conduct. So what you want to do is look for volitional conduct. If you've got it, it's obvious, just say you've got conduct. What do you do next with the conduct? Well, under all of our definitions for intentional torts, you're going to have to show that conduct caused a wrong and that conduct was intended to cause that wrong. Whether the wrong is a touching, an entry on land of another, an interference with a chattel, or intending to cause emotional distress. I think the safest way to analyze an intentional tort is start with the conduct causing the wrong and then see whether or not it was intentional. If you start with intent, you're assuming that you had conduct causing the wrong. You can do it any way you want. You don't lose points on this. I just think organizationally, if I were handling an intentional tort analysis, I'd say, do we have conduct that causes the wrong needed for that tort? Taking battery for an example, you need conduct causing a touching. Nothing else will work for battery. You need conduct causing a touching. Usually that's easy to see. And so establish that. Then see whether or not the conduct was intended to cause a touching. Okay, so when you get to intent, which is the major problem with intentional torts, is how do you prove intent? Well, there's law about intent. We've seen it ad nauseum. There's three ways to prove intent. Either your purpose or your desire was to bring about the touching, or someone claims I did not desire that. You say, well, at least you knew to a substantial certainty that a touching would occur from your conduct. If neither of those works, then and only then you need to go to transferred intent to see if you can find an intended tort that the court will transfer to the unintended tort. For purpose, students tend to get that wrong only because they get mixed up about what the purpose has to be. The way to make sure you don't get that wrong is don't start arguing or analyzing whether or not intent is present without first stating the law about what has to be intended. And time after time when I'm meeting with small groups of students, they get off on the conduct being, they clearly intended the conduct, therefore there's intent. Their purpose was clearly to bring about the harm, therefore there's intent. You've got to be more precise than that. You first ask yourself and tell me the law, what has to be intended specifically for this particular tort? So you'd start off with, in battery, the touching has to be intended. And then you will naturally flow into whether touching was the purpose of the conduct, or this guy knew to a substantial certainty there was going to be a touching from his conduct. If you don't do that, I've found in experience on looking over exams, people get off on all sorts of other purposes. And they begin to ramble or get it all wrong. So start off when you're analyzing intent by telling me law. What has to be intended for this tort? As we've seen, for battery, you've got to intend the touching, or the assault, the apprehension of that touching. So if you intend the touching or the apprehension of that touching, either intent works. So you got to remember, you got two intents that work for battery. So you state what has to be intended for this tort is a touching or the apprehension of a touching. Then when you apply that, you get into purpose, knowledge, or transferred intent. If you got to trespass the land, as obvious as it always seems, I may make it non-obvious or tricky, but you won't get tricky if you start off again with the law. What has to be intended is an entry. Then see whether the entry was intended. It'll keep you focused on doing intent correctly. So once you've stated what has to be intended, then you see whether or not in engaging the conduct, was it the person's purpose to intend that touching? Or if the facts show they did not intend the touching, at least was his purpose to cause apprehension of the touching? I've given exam questions where someone's aiming an arrow at someone merely to scare them, but the aim goes wrong and the arrow hits the person. Well, they never intended the touching, but they did intend to cause apprehension of that touching because the facts state they were trying to scare them. You will state that that works for the intended touching. While he did not intend the touching, his purpose was not a touching, his purpose was to cause apprehension of it, that intent is sufficient for battery, you move on. If purpose, or a synonym desire, works, you don't have to go to knowledge to substantial certainty, you certainly don't have to go to transferred intent, and you don't have to tell me about those things, because they would not come up in that fact pattern. You only get the knowledge to substantial certainty if purpose or desire doesn't work. And you only get the transferred intent if purpose and knowledge both fail. So just to go through what should be obvious by now, what do you need to prove has to be intended for each of the torts? Touching or apprehension of the touching for battery. Apprehension of the touching or touching for assault. Interference for trespass to chattel or conversion. So you start off with. In proving conversion, plaintiff will have to prove that the interference was intended. Then you'll go into using one of the three ways to prove intent. For trespass to land, it's obvious. Entry on the land has to be intended. For emotional distress, the distress has to be intended. Okay, the one thing to remember with all this stuff is do not get into the harm was intended or not intended. That's not a rule for any of these. The harm does not have to be intended. Don't get into saying the conduct was intended. We've already dealt with that up above where we had volitional conduct. Okay, knowledge with substantial certainty, where do students go wrong on that? You generally go wrong by not stating the phrase correctly. This person could have known to a substantial certainty. It's possible he knew to a substantial certainty. None of that works. Never use might, could have, possible, or any reasonable person in her situation would have known to a substantial certainty. Those phrases are all wrong. You've got to use the phrases that the courts use and that the courts accept. It's a subjective test. If it was not the actor's purpose to bring about a touching or an entry on land, whatever the tort is, then, well, despite there not being their purpose, must he have known, and must he have known to a substantial certainty that in engaging that conduct, it would cause an entry, it would cause a touching. It's a subjective test. Never use the word reasonable person when you're analyzing intent. Save it for later, where inevitably will come up. On intent, you got to prove what's actually inside their head. Did this